In the previous lesson, we concerned ourselves with one of the most simple questions concerning the issue of dispute resolution, and this was the question of essentially who the parties to a claim actually are. What is a claimant? What is a defendant? Who might a defendant be? What might a defendant be? And in what circumstances might it be difficult to identify a defendant? Well, in this lesson, what we will talk about is the ways in which we can identify a cause of action, looking at what a cause of action is, and thinking about ultimately what a dispute is fundamentally. This is part of the preliminary consideration still, looking at parties and causes of action. This won't be a particularly long video. There's going to be a bit of extension material in this video as well, so if you want to brush over that, it'll be on screen there for those of you who just want the SQE specification injected into your eyeballs. Fundamentally then, simply put, the cause of action is the claim that essentially allows a person the right to initiate legal proceedings. It is essentially something that we can boil it down to the set of facts which can give rise to a legal right to sue. That's fundamentally it. What is the thing that has happened that has caused you to allow you to be able to sue someone? What is the thing that has happened that has given rise to a dispute? That is fundamentally all a cause of action is. Sometimes in dispute resolution, a client may feel that they have a right to sue, but the facts might betray them in one way or another. And so, fundamentally, depending on the area of law in which you are dealing, you might find that the cause of action is different. So we will do a case study at the end of this video where we look at the cause of action for a breach of contract case. And it will be very familiar to you because it will be essentially what you have to do when you think about understanding the law of contract. And it is slightly different to the law of tort. We know that the law of negligence specifically, the cause of action involves a number of different issues. It involves the idea that there has to be identifiable a duty of care. That duty has to have then been breached, fallen below the standard of care, and then there also has to be issues concerning causation, concerning foreseeability and remoteness, all these different things as well. And so it might be the case that a person has acted theoretically negligently, maybe they have breached their duty of care, but there might not be any causation. It might be the case that there are new intervening causes, novus actus interveniens, or there might be issues concerning foreseeability or remoteness that makes it the case that there is in fact no cause of action. So that, of course, is going to be the subject of a lot of lessons in the law of tort. For contracts, it will be the subject of a lot of lessons in the law of contracts. And usually, a cause of action will occur in a situation whereby there is some kind of loss that is suffered. Okay, the loss might be financial. It could be physical harm, like personal injury. It could even be reputational damage in the case of defamation, which of course has to be illustrative of some kind of clear damage, some kind of loss. So, for example, if a person tells a lie about you on television and that causes you to lose your job, or it causes you to have an advertising deal be revoked or something like that, that's the kind of damage that you can then claim for in defamation. Or it could be just damage to property. It could be something as simple as that. Someone damaging your property, whether it be your real property or your personal property, your chattel, is still also an example of something that can be a kind of loss in which you might have a course of action. Now, the meaning of a course of action is actually clarified in a case, the case of Koch and Gill. This represents a bit of extension material. This is not necessarily required for the SQE specification, but essentially the case clarified that the meaning of a course of action refers to, and it clarifies what it includes. They said that it includes all the essential facts that a claimant must be able to establish in order to claim their legal right to some kind of remedy. And so where there are instances where such facts are in fact disputed by the defendant, the burden of proving those facts rests on the claimant in court. They are the one that is making the claim, and the burden of proof therefore rests on them to show that that claim is in fact true. So let's really finish this off and wrap it up by looking at a case study, a breach of contract case. So In a case study, such as breach of contracts, a course of action will require a number of considerations to be taken. And these are the considerations that you will understand when you study the law of contracts, or if you have already studied the law of contracts, you will be very familiar with this endeavour, you'll be very familiar with these sets of circumstances. So firstly, there has to be a valid and legally binding agreement between the parties as established. In order, essentially, for a breach of contract case to be valid, there must in fact be a contract in the first place. This is basically tautological. This is a priori in terms of your understanding. And so for a legally binding contract to exist, what do you need to have? Of course, those of you who know this already, there has to be an agreement. There has to be, which encompasses an offer and an acceptance of that offer. There has to be an intention to have legal relations, to basically engage in legal relations. It has to be an intention on the part of the parties that the agreement that they are coming to is one that is a legally binding agreement. And in England and Wales, there also has to be something known as consideration, something for something else. There has to be a quid pro quo, an exchange of obligations. One-sided contracts aren't legally binding in England and Wales. And so the party wishing to bring a claim, i.e. the claimant, must show the next point, which is that the party they claim to be at fault has breached their obligations under a legally binding contract. There's a contract, and they have to presumably show, if you want to bring a claim, you have to show, look, the person that I am contracted with, the defendant over there, has breached this contract. They have breached their obligations in this contract, and they have done so for the following reasons. They have done so by doing or not doing X, Y, and Z. Okay? And then the final point is it must be shown that they have, in fact, also suffered some kind of loss or some kind of harm which was caused by the breach on the part of the defendant. So the breach of the contract might mean that you lose thousands of pounds because, of course, the other person failed to uphold their end of the bargain. Let's say it's a contract for the sale of some kind of product. Let's say that perishes after a few days or something like that. You have a contract with the person to maybe to ship those products away, and let's say they're late or they fail to ship those products away, and therefore all of your product fails and your product perishes in some way. Let's say you're selling fruit or something, and you lose thousands of pounds because now that product is useless and worthless. That would be a breach of contract because they have contracted themselves. They have been contracted to deliver those products or to transport those products, and those products have now perished as a result, and you have now suffered a great financial loss as a result of that. And it has to also be shown that it was caused by this action. There has to be causation in this. So you have to also make it very clear that, but for the actions of the defendant in breaching their contractual obligations, I would not have lost this thousands of pounds in the perishing of these fruits that I have sold. So there has to, it can't just be the case that even if the defendant had in fact fulfilled all of their obligations within the contract and they had and you had still lost thousands of pounds, then you can't claim that those thousands of pounds from the defendant because, of course, he or she was not the cause of that particular action. So that's the final point that you need to make very, very clear. The breach has to have caused a loss in some kind of way. In contract cases, it's usually some kind of financial loss, some kind of financial harm. In tort cases, of course, it might be physical loss in terms of physical harm or personal injury. And we'll get to that when we look at tort cases in more detail in future videos. That's fundamentally what a cause of action is. And we are nearly at the point at which we're going to start actually looking at dispute resolution, actually looking at litigation. But we've just got one more point I want to go over, which is the issue of the international consideration, thinking about jurisdictional issues and the impact of Brexit on that particular line of inquiry.